The government's role is to consider whether the existing range of sentences is adequate. That has been dealt with in the previous reply. The actual sentences in individual cases are decided by the courts based on the facts of each case and based on the submissions by the prosecution and the defense. We should look carefully at the specific charges in considering the sentences imposed. Although the media often refers to the $3 billion money laundering case, the amounts and charges involved vary across the different cases. For example, one of the convicted foreigners is Haijin. He was sentenced to 13 months and 6 months imprisonment respectively. This sentence was for 2 counts of money laundering involving about $1.4 million, which were ordered to run concurrently, and a further 1 month's imprisonment for 1 count of resisting arrest. This resulted in a total of 14 months imprisonment for his offences in Singapore. The sentences meted out by the court for Su and the other defendants are comparable to sentences imposed in other jurisdictions. The penalties provided for Su's specific offence in law, I correct myself, the penalties provided for Su's specific offences in law are a fine not exceeding $150,000 or imprisonment for a term not exceeding 3 years or both. Additionally, $165 million, or about 95% of the assets linked to Su and his wife, were forfeited to the state. This voluntary forfeiture went beyond the amounts for which charges had been brought against Su. Such additional asset forfeiture, where the defendant agrees to the forfeiture, deprives criminals of their assets beyond the amounts which are the subject of the money laundering charges.
So can I just ask more broadly, and I know this may have bearing on the next PQ as well, because one of the questions that arises from the MOS's answer and MHA's answer is that these are not crimes of passion. Money laundering offences involve planning, deliberation, calculation. So can I ask, does Minister agree more broadly, without reference to any particular specific case, that a potential money laundering criminal will do their sums, including what is the chance of being caught, and if they are caught, what is the chance of being convicted, and whether the penalties will outweigh the potential benefits? And so can the Minister also tell us, does MHA, looking back at the existing cases and looking forwards, does MHA have a sense of how many potential cases of money laundering were strongly suspected but could not be caught and convicted? And will the Interministerial Committee look at tightening the evidential searching process and strengthening the potential penalty regime, if appropriate?
Yes, Mr. Speaker, sir. I think his question is more in relation to the next question in the order paper, but I will answer it nevertheless. As the member, Dr. Tan, would know, the Interministerial Committee was set up in end 2023 to review our anti-money laundering regime. The work of the Interagency Committee is still ongoing, and recommendations will be made available in a few months' time. But what I would say is that the interagency review would focus on 4 areas, and they are related to what Dr. Tan had shared in his SQ, which are that we are looking at what more can be done to prevent corporate structures from being abused by money launderers, how financial institutions can enhance their controls and collaborate more effectively to guard against and flag suspicious transactions, and how other gatekeepers in the ecosystem, which involve real estate agents, lawyers, precious stones and metals dealers, and corporate service providers, can better guard against money laundering, and of course, how we can strengthen our monitoring and sense-making capabilities to better detect suspicious activities. So I think potential money launderers, when they look at what Singapore's whole of government approach and whole of society approach is towards money laundering, they will make their assessment as to whether or not they would like to continue with these activities at a high risk of being caught. Thank you. In the Interministerial Committee's review, The Interministerial Committee will indeed consider the increasingly sophisticated ways by which criminals may seek to exploit our systems and make recommendations to ensure that our anti-money laundering regime remains effective in preventing, detecting, and enforcing against such. The Interministerial Committee will share its full findings and recommendations in the fourth quarter of this year. As for the adequacy of the penalties prescribed in the law, the Ministry of Home Affairs regularly reviews such, the last time being just recently in 2023.
I thank the Minister for her answer, and I've got a further supplementary question on this topic. Will the Interministerial Committee, in its deliberations, also look at whether there's an increasing nexus of money laundering with organized crime, including organized cybercrime? And I raise this because there were media reports of a foreign national arrested in Singapore following an extradition request. It was reported in the media that this foreign national faced charges, not just of money laundering, but also running a large-scale malware and botnet relating to cybercrime. And if there's an emerging nexus between money laundering and organized crime and other forms of crime, including cybercrime, will the Ministerial Committee look at applying the full force of Singapore's policy levers, including the ones we apply to organized crime today?
Indeed, money laundering and the methods employed by money launderers has become increasingly sophisticated. They undertake multiple layering processes to hide their tracks. And obviously, with greater digitalization, different categories of assets, it is becoming increasingly difficult to differentiate between legitimate and illicit fund flows. Earlier in my response, I had mentioned that we are taking a whole-of-government approach to strengthen our monitoring and sense-making capabilities, and this would include looking into areas of cybercrime. So I hope that helps address the member's question.
Just a question for the MOS. Lately, over the last 2 years in particular, there has been a term that is floating in the media lexicon, which is referred to as Singapore washing. Can I confirm whether the Interministerial Committee will also be looking at the various permutation and aspects of some of the claims made by individuals and media organizations worldwide about how Singapore is potentially used as a conduit for such money laundering?
Indeed, the Interministerial Committee is undertaking rigorous work to ensure that corporate structures in Singapore are not being abused by money launderers. Secondly, we are also working closely with our financial institutions to make sure that they enhance their controls, they do their due diligence on their customers' backgrounds to be able to identify the sources of their funds. And I also earlier mentioned other gatekeepers in the system, such as real estate agents, lawyers, precious stones and metals dealers, and corporate service providers. All these actions would help us better guard against potential money launderers trying to launder their monies through Singapore's ecosystem. Thank you.